Welcome to Talita. Talita Diaz is the Shaw Foundation Junior Research Fellow in Law at Jesus College, Oxford, as well as Research Fellow with the Oxford Institute for Ethics, Law, and Armed Conflict at the Blavatnik School of Government at ELAC. And I know she's shifting to another position, so she's always doing, very impressive things. At ELAC, she co-led the Cyber Due Diligence Project and currently works on the Oxford process on international law protections in cyberspace. Her current research interests include the application of international law to new technologies, including the internet and artificial intelligence, the regulation of online hate speech and information operations, such as dis and misinformation and war propaganda, as well as states' obligations to prevent, halt, and redress online harms. She's a principal investigator of Just Speech, a research project looking at the international law and policy of online hate speech, and Beat the Algorithm, a research and public engagement project aiming to develop new regulatory and computational models for recommendation for algorithms consistent with international human rights law. So Talita, welcome. Really looking forward to your talk on how we address and regulate online hate speech under international law.
Thank you so much, Sujata, for the invitation to be here today and for the introduction. I tried to share my screen, but it says host disabled participant screen sharing. So I'm not sure if this is supposed to, happy to give the presentation without the PowerPoints. Now I can do it. Okay, great. So can you see the slides now? Great. Okay, so wonderful. So I'll make sure to speak only for 15 minutes. So what I wanted to talk to you about today is, my current research on online hate speech under international human rights law, and in particular under the International Covenant on Civil and Political Rights. And how content moderation is a key tool to give effect to the International Covenant on Civil and Political Rights in this space. And so basically, the motivation behind this paper and the research more generally is a series of recent events that hit the news worldwide over the past few years, where we saw online hate spurring offline real-world harms in both developed and developing countries. So, for example, as we all remember, back in 2020, the January 6th riots in the United States Capitol building were in no small part fueled by some inflammatory tweets posted by the former US president, including this famous one that you can see on your screen. And as many of you might also remember, in 2018, the already precarious situation of the Rohingya ethnic and religious minority in Myanmar really spiraled out of control and evolved into killings, rapes, persecution, and other violent acts against hundreds of thousands of individuals, likely amounting to crimes against humanity, war crimes, and genocide, all thanks to an explosion of hateful posts on Facebook, such as the one that you can see on your screen, calling the Rohingya terrorist dogs and wishing them horrible deaths. Now, at the same time, we have seen instances of perfectly legitimate and innocuous types of speech being wrongfully taken down as hate speech or other types of objectionable content by platforms' automated content moderation systems. So, for example, in 2018, an extract of the Declaration of Independence, which was published by this Texas-based newspaper called The Vindicator to celebrate the 4th of July holiday, was mistakenly taken down because it contained a historical reference to the merciless Indian savages. So what we have seen recently are these binary, very reactive, and out-of-tune approaches to hate speech and other types of problematic content. So either online hate goes unhinged and has led to real-world harmful consequences, or things that may sound offensive to some but are not really harmful have been taken down in a big wave of what some have referred to as private censorship. Now, this problem of hate speech and the different ways to respond to it this is not new, right? We are all very much aware of how Nazi propaganda, for example, and Nazi hateful rhetoric more generally contributed to the Holocaust. And we also saw back in the 1990s how radio broadcasts, on the other hand, in Rwanda led to the genocide by the Hutus against the Tutsi. And hate speech has been a politically and culturally divisive topic for decades, especially because different people in different countries have different views as to how to balance or navigate the tensions that we see and we have between free speech on the one hand and other protected rights, such as, for example, non-discrimination, right, and the right to life. But you know, in this digital age, what has been unprecedented, really, and what has raised unique challenges are the speed, the scale, and the directness with which content can be disseminated online by individuals and even botnets. And what we have also seen recently, which is very unique to the digital age, is the automation of the processes by which content, especially sensationalist and hateful content, can be ranked and amplified online, becoming viral. And also the automation by which these types of content can be taken down by these automated online moderation systems. So this is the novelty of the problem, the uniqueness of the problem of hate speech online, right? And so it is against this background that my research has tried to answer three overarching questions, which remain underexplored in the literature. So the first one is, to what extent there is and there should be an international legal framework to tackle this multifaceted and complex phenomenon of online hate speech? The second question is, can this framework, if it exists, can it move us away from the leave up, take down binary, which we have seen recently on the issue, tackling hate speech in a more balanced, nuanced way? And the third question is, how can states, platforms, and other relevant stakeholders effectively implement this framework, if it does exist, of course, through different policies and practice in different parts of the world, including developed and developing countries? So this is these are the questions that my research has tried to answer, and in answering these questions, a paper that I have recently authored on this makes three key claims and overarching arguments. So the first argument is that because hate speech, online hate speech, is a global phenomenon, we really need global responses to it. And we actually already have a basic but workable legal framework that is universal in nature and can be applied to this issue. And this is precisely the International Covenant on Civil and Political Rights. The second claim that I make in the paper is that actually content moderation is a necessary policy tool to implement the relevant provisions of the International Covenant on Civil and Political Rights, or the ICPR, which are the rights to freedom of expression and information on the one hand, and the prohibition of certain especially egregious forms of speech on the other hand. And the third claim that I make in the paper in response to the third question, which is actually the most important claim that I make, its most important contribution to the literature, is that while the ICPR might be a little bit too general and somewhat outdated to deal with the problem of online hate and online content more generally, because it was drafted in the 40s and adopted in the 70s, so long before the internet even existed, we can actually read into it more practical, more granular, and well-calibrated guidance to tackle online hate speech today. And it is in trying to provide this kind of granular, more sort of like up-to-date guidance that I devise in my paper, what I refer to as a legal taxonomy of online hate speech, which is grounded in both the content of relevant speech acts and most importantly, the legal consequences that different types of hate speech might attract under the International Covenant. And so let me unpack these three arguments. So on the first claim, I argue that the ICPR provides a basic but appropriate international legal framework to deal with online hate speech, as well as offline hate speech, for four main reasons. So the first reason why the ICPR is important here is because it is an international human rights treaty, which is open for ratification by all countries in the world. And actually, the ICPR already counts with a large number of states parties to it. So there are 173 so far, including big powers in this space like the United States, United Kingdom, and a number of Latin American countries as well. And so because it's an international treaty, the ICCPR imposes binding obligations on states to respect and protect the rights to freedom of expression, the right to information, and the right to non-discrimination, all of which are relevant in this space, as well as other rights, other fundamental human rights. And the second reason why the ICPR is important in this space is because even though the covenant is not itself binding on companies as a matter of hard law, it is an important soft law mechanism in the corporate world, including online, because customers, online users are increasingly expecting big tech companies and small tech companies to respect human rights online. And so there is what we call a social expectation and a corporate responsibility for companies to abide by international human rights standards voluntarily, right? And also one of my arguments is that actually complying with human rights law standards gives companies more legitimacy when making decisions about what content to leave up or down. And in fact, most big tech companies like Facebook, Twitter, I'm not sure about how things are going to go for Twitter after Elon Musk has now, bought it and has changed things around to a significant extent. But anyway, Twitter before Elon Musk had actually committed, and also Google had committed and pledged to ground their guidelines in international human rights standards. And the Facebook Oversight Board in particular already refers explicitly and extensively to the ICPR in its decisions, right? The third reason why the ICPR is important here is because for civil society groups and individuals, the ICPR is an important advocacy tool that they can refer to when making demands to states and companies with respect to the harmful consequences of online hate speech. So, for example, a few weeks ago, Amnesty International published this big report concluding that Meta had a responsibility to provide reparations to Rohingya victims that were affected by online hate speech on Facebook. And this finding was heavily grounded in the ICPR. And the fourth and more general reason why I think the ICPR is important here is that it provides all relevant stakeholders in this space with a common universal language with which to deal with the problem of online hate speech in a balanced way. And I argue further in my paper that the ICPR, because it's so flexible, it allows states and all these other stakeholders to deal with the problem in a way that bridges national and regional divides, because the ICPR gives states and other stakeholders tools that are flexible and tools that allow them to decide which types of online hate speech should be limited and which ones should not be limited on a case-by-case, very contextual basis. So this is what I argue in my paper. The ICPR is important because it's flexible, gives deference to different states and different companies operating in this varied space. So there are two relevant provisions, and I'll go very quickly through them of the ICPR. So the first provision of the ICPR that is important here is the provision that Article 19, which protects the rights to seek, receive, and impart information, ideas of all kinds. So this is the provision that protects the rights to freedom of expression and information, regardless of frontier. So the right is not limited to one single territory because the transmission of information is inherently boundless, right? So this right is inherently transboundary. And it also includes different kinds of media, different kinds of expression, orally, in writing, or in print, in any form. So art, it could be through any other media of one's choice, including online platforms, right? So this right applies online as it applies offline. Article 19, on the other hand, adds an important caveat that the rights to freedom of expression and information carry with them as special duties and responsibilities. And this is precisely because the unrestrained enjoyment of those rights might interfere with the rights of others or other important public goals. So, for example, if we let people say whatever they want anytime, this might actually have a chilling effect on other individuals' rights to freedom of expression and information. So this is why it is important to allow states to limit the right to freedom of expression and information in some circumstances. And according to Article 19, paragraph 3, these circumstances in which states are allowed to limit speech are very narrow, they are exceptional, and they are exhaustively listed in Article 19 as the respect of the rights and reputations of others, the protection of national security, public order, public health, or moral. So these are what we call the legitimate grounds in which states can limit speech. And speech can only be limited by law. So states need to enact clear laws to limit speech, and they must do so in a necessary and proportionate way. And this includes limitations for on offline as well as online speech. So if states want to pass laws, for example, to tackle disinformation and online hate speech, they need to do this by adopting a proper legal framework, right? The other relevant provision on online hate speech is Article 20 of the ICCPR, which is a more specific provision, specifically requiring states parties to the ICCPR to prohibit by law, though not necessarily criminal law, propaganda for aggressive wars and advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. So this provision was drafted right after the Second World War. So it was an important reaction to the way in which speech was used to drive atrocities in Europe during that time. But it's also very controversial because it forces states to prohibit these types of speech, which might go against constitutional protections in countries like the United States, for example, which under the First Amendment really does not allow the state to limit these kinds of expression in most instances, right? And so it's a very controversial provision. But the important point, the important takeaway for us is that no state, even though some states have reserved the right to adopt legislation prohibiting incitement, no state denies that these kinds of speech acts are dangerous enough to justify more stringent restrictions, though not necessarily legal prohibitions. Now, the other argument that I make in my paper is that actually content moderation is necessary to give effect to those two provisions of the ICCPR. And this is because content moderation is really about adopting different kinds of limiting measures, different types of limitations on speech that are well calibrated to the seriousness of the speech in question, right? So content moderation is often associated with content takedowns or content deletion, but this is not really the case. Content deletion is just one type of content moderation, right? Content moderation is actually understood more broadly as content governance or content management. So basically including any measure to review, to manage, or to curate or otherwise affect the publication or dissemination of an individual piece of content. And so we really need to debunk this myth that platforms only have in their toolbox content takedowns, right? So there are actually a number of other measures as part of a sort of like a concerted, comprehensive content moderation effort that they can adopt to tackle online hate speech. And this includes, for example, labeling, which has been heavily used in the context of COVID-19 misinformation, but not so much for hate speech, right? There's also deprioritization or content demotion, right, as a measure to tackle online hate speech, and also digital nudges, for example, directing users to certain types of pages, right, to inform them about the consequences of online hate. And also the promotion of positive forms of engagement, positive forms of speech, like counter speech. So there are a number of content moderation measures that are actually essential to give effect to Article 19's framework, especially the requirements of necessity and proportionality when limiting speech, including online hate speech. Now, my third and final point, and I'll end there, is this taxonomy of online hate speech that I have sort of like devised or proposed, building on the language of Articles 19 and 20. And basically, like what I propose in my paper is that actually this is already there in sort of like in between the lines of Articles 19 and 20, but actually this is a sort of like a more specific way, a more specific interpretation of those provisions that is well tailored to the phenomenon of online hate speech. And so what I argue is that actually there are three relevant categories of online hate speech. So one is prohibited speech, the second one is limited speech, and the other one is protected online hate speech. So prohibited online hate speech actually mirrors Article 20 of the ICCPR, and these are those very serious types of online hate speech, which include online propaganda, war propaganda on the one hand, and incitement to violence, discrimination, or hostility on the other hand. And these types of online hate speech, because they're very serious, they're intentional, and they're proximate to actual acts of violence or harm or physical harm or otherwise harmful consequences, they actually need to be proactively limited and prohibited by states. The second category, and for example, an example of this kind of speech were these tweets or posts that we saw at the beginning of the war in Ukraine, actually inviting people to kill Vladimir Putin, for example. The second category is limited speech, and it really mirrors the types of speech that can but need not be limited under Article 19.3 of the ICPR. And so basically this category requires a careful assessment on a case-by-case basis by states and by platforms as to which whether or not any particular type of online hate speech should be limited in the particular context at hand, taking into account things like the historical social context, who the speaker is, what the audience of the Speech Act is, and the language used, whether it's explicit or not, and so on and so forth. And so one example of limited online hate speech would be Holocaust denial, which in some countries is actually prohibited and should be so, but in other countries is not so serious as to demand or invite legal prohibitions or limitations. And finally, the third category that I argue in my paper is protected online hate speech, and it includes things like cartoons, satirical cartoons, and these are protected because they don't really target individuals, which are the subjects protected under international human rights law. It really affects institutions like religious institutions or governments or religious figures. So these are not targeting individuals. So as a matter of principle, these kinds of online hate speech acts should not be limited. But, you know, an important caveat to this classification exercise is because it is context specific. And this is because speech at the end of the day is and language in general is inherently contextual, right? So we need to take into account the particular context at hand when making those assessments in any case. So just to conclude, the ICPR is not a panacea or a silver bullet to resolve the problems that online hate speech gives rise to online or offline. It's only one piece of the puzzle, and it's a very messy puzzle, but nonetheless, it's a very valuable piece of the puzzle because it's already there and it can be interpreted in a very practical and granular way. And it gives states, online platforms, and other stakeholders a common universal framework to address the problem. And the main takeaway here from my research is that there's no one-size-fits-all approach to resolving the problem, but we actually already have the tools really with which to make these assessments in particular contexts and particular situations that can bridge regional and national divides on this very controversial issue. So I'll end it there and happy to take questions.
Fantastic. Thank you. So if you'd like a question, you can put in the chat. I can monitor that, Talita. You can see that yourself, or just raise your hand. So Thomas, go ahead.
So I see two different dimensions in which you can draw the distinction between different kinds of these utterances in the broad sense. One is that you look at the intent of the speaker. So is the speaker a hater? Is this born out of hatred? And you often or sometimes use the word targeting, you know, what is being targeted here? And that also refers to the speaker. Then there's the other dimension of the effect in the world. And here the word incitement was common in your paper.
Yeah.
And so to incite something, there has to be an actual effect, right? If I call somebody a penguin or something, it could be that I'm full of hatred, but people just laugh and there's no effect at all. And I've not incited anything. So now when you bring the human rights documents in, from what I understood, they seem to focus on the second. They seem to focus on effects. And so it doesn't matter whether I am full of hatred, so long as what I say has no effect in the world, I'm just okay because I've not endangered anybody, no national security and so on. Maybe morals, you might say, you know, I'm an immoral person for having these feelings about a certain ethnic group or something like that. But anyway, that's what I wanted to ask you about, you know, how these two strands, the speaker side and the effect in the world side, come together in your thinking.
No, that's an excellent question. And it's an excellent question because the definition of incitement within that particular provision of the ICPR is super controversial, right? And it's controversial because different states define incitement in different ways. And in particular, different states define the threshold for criminal incitement in different ways. So we have in the United States, the Brandenburg versus Ohio test, for example, which basically says that advocacy for hatred can only be prohibited, whether criminalized or otherwise prohibited, when there is incitement to lawless, imminent action that is likely to materialize. So that's the test under the Brandenburg versus Ohio case decided in the 60s, right, by the Supreme Court. And then in the context of the ICPR, and other states define incitement differently, but in the context of the ICPR, actually, so you mentioned the intentional bit, so the subjective aspect of it and the objective aspect to it. So actually under the ICPR, and I say this based on the guidance that the Human Rights Committee, which is the authoritative body that interprets the ICPR, the Human Rights Committee has said that actually incitement is an inchoate act. So by inchoate, I mean it's not something that actually needs to have any particular result. It doesn't have to have any particular effect or consequence. And so the intent element, so the subjective element, is much stronger under the ICPR. That is not to say that, you know, consequences or likely consequences are not entirely immaterial, because they are. And so, but the key there is to take into account the likelihood. So basically, it's not like the incitement has to lead or to have any causal connection to any particular effect. So effects are not necessary, but we need to assess the likelihood of the speech act. It's not the same thing as the Brandenburg versus Ohio test. So we don't assess imminence. Imminence is not key, and likelihood in the same way as in the Brandenburg versus Ohio test is not necessarily decisive either. But we do take that into account, like whether or not the incitement is likely to lead to a certain effect. We do take that into account when assessing whether or not the criminalization of incitement or the prohibition of incitement is necessary. So this is part of the necessity and proportionality test under Article 19.3 of the ICPR, which applies to Article 20 of the ICPR. So basically, the bottom line is, okay, it's incitement does not need to produce any particular consequences, and it doesn't have to be likely to lead to a particular result to be prohibited. But when we assess, when we sort of like calibrate the exact measure, the exact prohibited, the exact way in which we're going to prohibit and to more generally tackle these kinds of incitement acts, then we need to take into account the likelihood as one piece of the puzzle, as one relevant sort of like element, if that makes sense. So,
I can be guilty of incitement, even though the question, whom have I incited, has no answer. You have incited nobody, you failed, nobody listened to you, everybody laughed about you, but you are nevertheless an inciter because of, all right.
It's a bit controversial, and it's the reason why that provision has been sort of like a number of states have reserved their rights to adopt prohibitive legislation under that provision, like the United States, the UK, Australia, the Netherlands. So it's a controversial provision, but it's there.
Thank you. That's illuminating.
Are there other questions? And Talita, I have a question for you about the constitutional constraints. So as a constitutional scholar, you know, the US is particularly problematic because, as you say, not only are there no restrictions permitted, but then they've gone for the very unoriginalist interpretation of extending that right of speech to corporations, for example, including in the form of campaign contributions. And these decisions have now made regulation even more difficult because now there's going to be a lack of, you're going to now have legislators that are disincentivized to to create any kind of proportionality, and a lot of those standards for regulation, even for political speech, have now been eliminated. So, but I guess in the US, it's always challenging, how to get around that constitutional constraint. I always thought the German constitution, the basic law, was very interesting because of the prioritization of the right to dignity, which again is a way to still have a robust protection for speech, but to limit it only in the cases where propaganda is now leading to that violation of the competing right to dignity. I wonder, I don't know if you've thought about this in the US context, because I think about it a lot. Is there something else in the Constitution that we can balance against the right to speech and now make it a competing rights issue, just like they've done in Germany, to allow some more regulation of this kind of speech? I don't know how that's possible, but even theoretically, is there some avenue for that beyond just the implementation?
Yeah, that's another excellent question, because this is a very controversial topic, and I'm sure you might know that there are a number of cases now before the Supreme Court, at least 2 cases before the Supreme Court on content moderation in particular. And there's another case, I think, imminent before the Supreme Court about the right of whether or not companies have freedom of expression rights, to the point that states cannot really regulate, motivated by that Texas law that is trying to impose on companies sort of like non-discriminatory content moderation obligations, right? So that's the net choice litigation case. But anyway, so this is a very ripe time to discuss these issues in America. My view is that there is no principled obstacle to having freedom of expression balanced against other rights, even within First Amendment law. And I say this because if you look at, for example, a number of regulations about broadcasting, right, about traditional media, there are a number of limitations already, right? So as a matter, there is no inherent sort of like obstacle to this. It's just a question of what the courts think is convenient to limit at a certain point in time, or what not to limit at another point in time, So I think it's more a question of, what the Supreme Court decides, are legitimate or constitutional limitations to speech or not. But I think, I think one important reason why my answer is that there is no obstacle to having freedom of having a more sort of like balanced approach, right, to these issues, right? Like following like the German approach, for example, but also like the ICCPR, which focuses on proportionality rather than rights as trumps, including freedom of expression, right? The reason I say this is because, if you look at even like the Brandenburg versus Ohio test, it only applies to prohibitions, right? It doesn't apply to other types of limitations on speech. And so there's an avenue there. So we tend to think about, limitations on speech, and going back to my point about content moderation, right, being associated with content takedowns, we tend to associate limitations on speech on deletion, censorship, and this is not the end of the matter. Actually, there's a range of measures that, short of censorship, short of like prohibition, short of like prohibitive laws that we can adopt that are sort of like considered to be indirect or less direct limits on speech that are available, that have always been available, and we don't really think about those. And these are already permitted under US law anyway, under US constitutional law. So I think that's where the answer might lie. If you look at FCC regulations, for example, I think we can analogize to some extent. And even though companies might have First Amendment rights in the US, I still don't think that this is an impediment to regulation in this area, because again, we can balance these rights with other protected rights, like human dignity, like the right to life, like non-discrimination, and the right of other people to freedom of expression.
Thank you.
But this is a very fascinating topic, yeah, especially in America.
Yeah, for sure.